Hello everyone, welcome to AptiPlus. Friends, we are starting a complete new session on the Hindu editorial analysis. This is basically for the student who are preparing for civil service examinations, particularly benefiting to the student community for the mains, pre, essay and other aspects of the civil service examination. Friends, this is a complete new initiative by AptiPlus where we'll be analyzing the editorial of Hindu on a daily basis. So let's get started, and I wish you all the best for the student who are preparing for mains this particular year and the coming years. This is going to be beneficial for all the students. Let's start. Friends, before starting, we'll just get an overview what all the editorials in today's newspaper. So the first editorial talk about the Gujarat model. Right? Gujarat model, how the Gujarat model has scaled to the national level. It's basically the governance part, right? It's not that relevance for your mains asset because it's more government oriented. Fine. The other editorial which is there in today's newspaper is the absence of good law. This editorial basically talks about the procurement issues. We'll get into that. The other editorial, which is like qualifying leader for the position, is this is by Subhas Kashyap. You can read it out, but not much again for the mains examination. This is again the ethics cannot be outraged, where we talk about the ombudsman rule. External news ombudsman is there, and these are the two things like Shanghai is going on the recent the prime minister visit. So this and these are the missing remedies regarding that doctors protest and the Calcutta. So we'll be precising for the news which is more relevant in all the four. So we'll be proceeding with the absence of good law. Fine. Friends, in this particular editorial, the writer, the Anil Raja, talks about the legislation important in India, the public procurement legislation, which is very important in the time being. This is because in the recent, the Supreme Court has expressed their concern regarding that because of the Writ petition. What is happening? The citizen of India is empowered with the Writ petition, Writ pass, and what is happening that every like single and big cases is being tendered to Supreme Court for this. People are claiming their rights. So what Supreme Court has said, they had expressed their grievance. They have shown their concern that this why the government is not formulating a proper legislation, a proper body, a proper governing body, so that people do not have to approach to the Supreme Court in large. See, because I can tell you, Supreme Court being such a vast country and just controlling the entire thing, it become impossible for them to get the immediate effect of this cause and pros, right? So it has just asked the central government, it has raised the concern that you people come up with the proper legislation so that they do not have to approach to the Supreme Court. So before starting this, I'll give you all the overviews, the nuances of the articles, everything, so that you can get a crisp idea what exactly this is talking about. So let's get started. So first and foremost things come to your mind, what is public procurement? See, public procurement can be defined as the acquisition. It can be defined as the acquisition whether under the formal contract or of work, supplies to the public bodies. So basically it's a process, it's a public procurement. There's a measure is the acquisition part, right? Again, if you talk in a large, it's like it range from the purchase of routine supplies. Routine supplies means they're the frequent supplies of some of the items which is there, like bidders are there, tenders are there. Our services, our formal tendering, just I talked about the tendering, the formal tendering is also there. So this it talk about in the large, and it goes for the infrastructural purposes as well as many other purposes for this, but to be precise, it is more about the industrial project. Okay, friends. Now moving ahead, if you understand, because this entire editorial is about public procurement legislation, so you need to know about what exactly is the public procurement. Apart from that, if you can move ahead, so this editorial also talks about the government, despite the government has not taken the adequate steps, the adequate legislation, the Writ petition provided by the Constitution to the citizen of India. So what exactly the Writ petition is, considering that this editorial is being viewed by a layman starting, I consider that you people have just started the preparation as well. So I'll be dealing everything in complete sense that you get a holistic picture of that idea, right? So what is the Writ petition? See, basically the Writ petition is a formal writing order by a court. It's a formal writing. So it is like a warrant, order, direction, or any other things. So basically Writ can be issued by Supreme Court or High Court. That are called writs. A Writ petition is filed, and if you're going to file the Writ petition in High Court, you have to go by the Article 226. Article 226. And if you're just going to the Supreme Court, you have to go by the Article 32. But if you talk about these two articles in large, the Writ petition of the High Court has a larger extent. And it goes to constitutional right as well. And when people can file the Writ petition, when their fundamental rights are violated, their FR basically, the FR being violated. So now let's jump into the editorial. So basically what NL Raja want to say that the government has not formulated any procurement law despite the fact that it has been initiated from 2012 itself. It has been started from 2012 itself, and again the revamping has been done in 2015, but still there's no concrete step by the government. And as you know, the procurement laws are very important. We have initiative of Make in India as well, so everything get mud ups, no, it's mangled. So it need to be step by step in a chronological manner, so that the concern of the public procurement is taken well. So now let's understand more into the details of this editorial. So basically what happened, that what was the background? The NL Raja talk about the background of the procurement policies. So what happened, that the UPA government in 2012 has formulated the bill, initiated the bill to regulate procurement with the objective to ensure transparency, accountability, profitability in the procurement process. But sadly, this particular law was not been enacted and was not come to the action. What happened again? The NDA government, which come to the power, so they have revamped the provision of the earlier bill, and they have come with the public procurement bill. But still, there are some tooth and nail which is not still there in that particular bill. So that caused the concern for the people, for the concerned people with the procurement laws. Moving ahead, so basically, when you talk about the regulation, the NL Raja in this editorial talk about the regulation process. See, we have the Competition Commission of India, CCI. CCI is the commission which deals with the regulation of that procurements, okay, and it prevents them to ensure that the fair trade is ultimately the consumer benefit. So it is maintaining a transparency and accountability. Okay, friend, transparency and accountability. So these are the concern of the Competition Commission of India. Apart from this, if we talk about there are some international agreement which India is bound to. See what happened, if you have two legislation, one you have your at domestic level and other you have at the international level. So the thing is that when you are committed to the international, see the trade which is going, the everything is like people are from like global world is still approaching India for their manufacturing hub. India has initiated for Make in India initiative as well. So if you talk about the international agreement, we do have the signatory. We are the signatory of procurement agreement with WTO, World Trade Organization. Okay, we are the signatory of World Trade Organization. Fine, friend. So do you understand how important is to formulate a law? Because being the signatory, you don't have a proper and stringent law, a comprehensive law, a holistic law, so that can provide a redressal to the people, to the concerned community of the procurement. Fine. Moving ahead, Anil Raja also talk about, he's just forecasted how the procurement accounts for 30% of the GDP. This figure is very important. You mind it. This is for the 30% of the GDP. Fine. I write it again. 30% of the GDP. So this accounts for the 30% of GDP. Now moving ahead, the Union Cabinet, the recent Union Cabinet chaired by Prime Minister has approved the National Procurement Policy. They have approved it in 2015. They have approved it with the aim to encourage the Make in India. See, Make in India is a great initiative by the government of India to make India a manufacturing hub itself. So being labor incentive country, we can, because still we have importing many things from China and other international countries. So the prime motive of this Make in India initiative is to make India a manufacturing hub, but the loopholes lies is the procurement law. So you need, these are against the cons. When you write on the examination, you need to take in care of that procurement law is the utmost important for the need, because it cannot proceed further you for the Make in India initiative or the manufacturing hub, right? Again, if you talk about the current context, is like the policy aims to maintain the promoting India Making initiative and ensuring the timely quality, just from the timely and the quality and the value added products, money products. So ultimately, in large, to benefits the people associated with the procurements, right? Also, in the present context, it aims to promote the manufacturing. I just told about the manufacturing. As I told you, the manufacturing is the utmost important thing for the time being, and the production of goods and services in India within a view to enhance income and employment. See, the people are still, it's not that equipped. I mean, you can see the unemployment ratio is very high. So you cannot give employment to everyone. So you have to seek in another way to get into the employment, right? So you can only do by strengthening your labor intensive market, and that too with the manufacturers. Fine. Now we're moving ahead with other editorial. Now here we talk the Anil Raja also talk about the inadequacies in the states. Fine. He has raised some other concern ki how the state has not been just has not provided the adequate steps, the adequate procedures, the adequate laws to get the regulation process, the procurement process in the stand. So we will get into that also. So the concern raised by Anil Raja was that, and this editorial is like absence of legislation. Absence of legislation means that there is no comprehensive parliamentary legislation for the time being. At the present, only the CCI and other regulations which are there, that are being regulated. Fine. So the absence of comprehensive parliamentary legislation is still a big task for the central government. Apart from that, there's only laws that are puzzling and confusing to the people concerned with the procurements. What is that? So there's only puzzling and confusing regulation, guidelines, and rules. So see what happens until and unless you have a transparent, hassle-free process, you cannot make through. It create a barrier. It create a red tape for the people involved with that particular business. Another concern is like in the Constitution of India, we have provided with the Article 282. 282 talks about the financial autonomy of the public spending. There is no further provision that address to the guideline of the public procurement, principal policies, and procures of the grievances redressal. So this is being provided, this is being entrusted by the Constitution of India. So this provision need to be taken care of while formulating the other policy as well. And now moving ahead, I'll just tell you what exactly the Article 282 is all about, because you still may land with the confusion that what Article 282 is. So Article 282 empowers the union or the state that may grant for any public purposes. They may grant for any public purposes. Okay. Other than that, what they can do, they can assess them. Financially, they can assess them. So these are the basically, you don't need to get into the details of the two articles. It was just mentioned in the article, so that I wanted to clarify to you. Fine, friends. Now moving ahead, the other concerns which is being raised and which is needed for the time, you have to use this content in your mains answer as well. So what is the inadequacies? Inadequacies in state laws. So state laws, public procurement are not better. They're not providing the adequate or effective. They're not providing the adequate or effective dispute resolution mechanism. It's not adequate. It's not transparent. Right? It's not transparent. So that need to be taken care of. We need a proper law. Fine. Now the state procurement is regulated by state acts, and you have seen that the other laws which are there in the state that are regulated basically by the state act, and that are only active in 5 states. See, we have 29 states in India. Okay, and only the 5 states are having the state procurement law. That only two with the Tamil Nadu, Karnataka, Rajasthan, Andhra Pradesh, and Assam. So these need to be extended. If you write in your mains examination, you understand this editorial. So what we need to do for the time being, the time of the hour is to increase to get the number of other 24 states to into that. Fine. So other state also need to have a stringent regulation of procurement policy, public procurement policies. Now, apart from this, the grievances redressal mechanism. The grievance redressal mechanism is also very important. The grievance redressal mechanism provide the act that are not confidence inspiring, as they are neither independent nor effective. It's not that effective. Okay, so the effectiveness of this law need to be taken care of, and we need a strict and transparent rule. Fine. Now moving ahead, just apart from all these things, you need to go for the way forward. What exactly could be done for this? So in this particular case, what happened? So the Supreme Court in Madras Bar Association versus the Union of India has, in which he has told that the court spell out the requirement of tribunals. So basically, see, when you come out talk about the stringent law, the regulation, the policies, when you talk about the rules, when you talk about the policies, when you talk about the administration, now there comes to a tribunal. There lands up to the grievance which can be addressed by the tribunal. So in this particular case, the Supreme Court, where the Union of India and the Madras Bar Association were associated, the requirement for the tribunal was very important. They pointed out the post to qualify them to be efficacious alternative remedy. So this is a great concern, need to be taken care of, that there need to be have a tribunal. Tribunal is needed to effective remedy for this particular procurement policies. And other important thing, the other way ahead would be effective and robust procurement laws. So this is very important. You need to have an effective, robust, and a well-checked process so that to affect the people in large. Okay, so this was basically the summary of this editorial, in which he talk about the absence of good law, the absence of public procurement legislation. So the Anil Raja has just given a picture, and we have analyzed in a well structured and understanding you the other nuances as well. So hope this editorial gonna benefit student community, people from the civil services background, the aspirants of civil services. And I thank you so much for the listening and wish you all the best. If you find any problem, just ping that message, just let me know in the comment section that what other things you wanted to know. Thank you so much for listening.